I'm Jaime Levine, Executive Director of Elder Law Advocacy, and today I am speaking with Caleb Logan, one of the litigation attorneys in the organization. Thank you for joining us, Caleb.
Happy to be here.
Um, so, um, you have worked on a number of cases, a couple of which you filed on your own, and then you've also worked with another attorney in Northern California on a couple of other financial elder abuse cases. So I wanted to have a conversation with you about what the legal landscape looks like right now for victims of financial elder abuse. So, can you say something about the cases that you've worked on and what you were trying to achieve?
Right. A lot of the cases, as you say, have focused on elder financial abuse claims. And with that, that means that they're focused on whether someone took or appropriated or hid or maybe just kept the property of an older adult. And the way the statute says it is that the taking was for a wrongful use or with intent to defraud. And there are some other situations as well defined in that law. But so essentially, we're looking at issues where property was taken and it was done so wrongfully at the
Mm-hmm.
end of the day. That can manifest itself in several ways. And so some of the cases I've worked on have been predatory lending cases. Others have been against financial institutions where the financial institutions arguably uh, don't have the necessary procedures in place to stop financial elder abuse from happening. And so it's quite a broad law, and that results in some broad litigation
Mm-hmm.
approaches. And but yeah, that's the basics of it.
Okay. So let's talk about kind of a typical fact pattern when it comes to a situation where a bank didn't have the requisite safeguards in place. Like what was the role of the bank in those kinds of cases, and what ended up happening with our client, so a victim of financial elder abuse?
Right. With a lot of our clients, they are making very erratic transactions that are induced by a scammer that is usually impersonating someone else. So, one client, he was told that he won the lottery, for example, and sent a lot of money to collect on his winnings. And so there are transfers there that were
So,
involved. Hmm.
what do you mean? So this is something that we hear about all the time, but what does it mean to send money to collect your winnings? How does that work?
The scammers are very good about coming up with reasons that you need to give them money. So, for example, a lottery scam, it could be that it's held in another country, and maybe you just need to pay a certain amount of fees so that it can clear customs or something like that. Some excuse that might seem reasonable, even though it's not if you look into it. Or and then once you make a payment, there will be other excuses that come along the way, like there was an issue with the New York Federal Reserve Bank. They aren't letting this go through. You need to pay for that process to work itself out, and so on until the person either runs out of money or realizes it is a scam, and stops. And there are other issues where a scammer could impersonate uh, a, a legitimate business like Amazon or Best Buy. The Geek Squad had a lot of scam cases where people were impersonating them. And so they're always demanding payment in some form, saying that it needs to be given for whatever reason it is in particular, and then just getting as much as they can out of the person before they realize it's a scam.
Okay. So there are a lot of different ways that scammers can convince people to send money. So
Yes,
sometimes
right.
it's the promise of much more money, and other times it's basically just them getting access to your computer and convincing you that you have to send them money because something's happened with the account, or maybe you owe taxes, or whatever it is.
Right.
That's almost an aside when it comes to what we're talking about today. So, what's the bank's role when someone's been convinced to send a huge amount of money?
To be honest, it depends on who you ask. I think that we as advocates would say that the banks need to be more proactive in their role and making sure that there are appropriate flags in place so that if a transaction is truly erratic, that it is, there is some friction, as regulators call it. In other words, it could be a teller stopping a customer and asking them pointed questions about the activity. Who is it going to? Are you aware that scammers often tell you that someone in your bank is in on the scam and you need to send the money? Or are you aware that scammers often tell you to make a duplicate transaction of a fraudulent one that allegedly happened beforehand so that they can cancel out? That's what they tell a lot of people.
Mm-hmm.
So things like that, we would argue that the banks need those in place. I think that the banks would argue differently, and so their perspective would be that they aren't on the hook for how people use their money, and their customers are free to use their money as they wish. The
Mm-hmm.
banks are not guarantors of that money, therefore, they have no obligation to stop these transactions from happening.
Mm-hmm. Yeah, I just want to take one step back. So the first part that we discussed was the scammer has convinced a senior of something that has happened. Usually, there's some urgency to it and some
Mhm.
fiction that they've created, and then the older adult then has to send money. So how are they actually doing that? What's the mechanism that they're using?
It can take a lot of forms. So, for investment scams, it might be cryptocurrency, with the cryptocurrency wallet funded by transfers from the victim's bank account. For other cases, it could be a cashier's check that's then FedExed or sent by UPS overnight to a location. It could be um, a cash withdrawal or a check withdrawal to purchase gold bars, or maybe the cash is just picked up by a courier,
Mm-hmm.
because the scammers have basically networks of couriers who drive all around the country and pick up cash or gold bars, whatever it may be, from a victim as part of the scam. So it could be that. It could be just a wire transfer to a bank account in the US or internationally. And so there are a lot of different mechanisms involved.
Okay, but that's the point. That's the sort of the point where they're interacting with the bank, right? They have been convinced to send money, and now they're either taking out a bunch of money, or they're trying to transfer a bunch of money, or they're trying to buy some huge thing.
Right.
Um, and that's the point where, from our perspective, the bank has an opportunity to try to make sure that the scam isn't going to be successful.
Right.
And so we're trying to figure out, like, what is it that the bank can see? Because they have all kinds of supervision going on. Like we all know that we get notifications when we spend too much money, or the bank suspects that somebody's trying to access our account from the wrong IP address, or
Mhm.
things get blocked because we go on a trip somewhere. So the banks are trying to figure out situations where consumers or the bank is going to potentially lose money. But that's the friction point where one of their elderly clients is trying to transfer a really unprecedented amount of money. That's usually what's happening.
Right. And for in person, well, actually, it doesn't need to be in person necessarily, but for the larger dollar transactions, I think as low as $5,000 for suspicious activity reports and then $10,000 for currency transaction reports.
Mm-hmm.
Those are federal reporting obligations for certain transactions that trigger a manager's review of the transaction. So that's another friction point beyond the distinction, I think, as you pointed out with credit cards, the bank is extending its own money to the consumer, and so they are very protective of that money and monitoring it very heavily. Whereas with debit cards, the same protections are not typically used. So you can use a debit card in another state and not trigger any sort of review process. As far as we know, of course, it could be that the bank's internal system has some sort of flag, but there's no automatic text message to the consumer, things like that.
Hmm.
Um, and possibly also with the lower dollar transactions, there wouldn't be a reporting obligation either.
Right. So the reporting obligation is it's either triggered by a $5,000 transaction or a $10,000 transaction of some kind?
Yes, based on the type of report, there are different dollar amounts for the type of reporting required, and the suspicious activity reports have different dollar thresholds based on what exactly is at issue.
Mm-hmm.
Um, but yeah, essentially 5,000 and 10,000 the last time I looked at it.
And in those cases, a manager has to actually approve, has to see the transaction or approve the transaction. What is actually required?
Yes, they have to approve it essentially and fill out a report that they file with the federal authorities.
Okay. So I guess even say it's $10,000, just to kind of be generous with the bank. Um, there's some people who have 10,000 transactions all the time, and there's some people who've never had a $10,000 transaction ever in their entire history with a bank.
Mm.
So you would think in those cases, that's a real opportunity for a manager to say, well, this is really a situation that has to be scrutinized.
Right, absolutely. The more erratic a transaction is, or the more unusual a transaction is for the consumer's account history, uh, then the more red flags that should be raised.
Okay. So in a case like that, I think you've had cases that are, you know, against banks in situations where there have been large amounts that have been transferred. What is it? What's the legal landscape right now? Like, what are your causes of action, and what are the obstacles that we have to recovery?
It depends a little bit on the circumstances of the case. So, all of them can involve an elder financial abuse claim, and that would be kind of the focus of the case in that situation. But there are other claims that you might be able to bring based on the situation. So, one claim that attorneys often will include is an unfair competition law claim,
Hmm.
and that's just based on unfair or deceptive business practices, essentially. Often it could be just the unfairness or the deceptiveness of the bank not having red flags, but advertising that it does, and not having the friction points that it advertises that it does. And another claim could be if there is any identity theft on the account, then you're able to dispute that with the bank. And if the bank fails to take a reasonable investigation, there's a $30,000 civil penalty
Hmm.
that can apply. And for older adults, that would be trebled to $90,000 potentially. Then there's also a related penal code provision that says that when an account is opened in your name, and there are all sorts of accounts that this applies to, not just bank accounts. But when that account is opened by identity theft, you're able to get information from the person holding the account. And if they don't give you that information, then there's a $100 per day penalty. So $300 per day penalty if we're talking about trebled damages for older adults. That could apply. And then there's also more generally a negligence claim, possibly if the situation does not involve a wire transfer or a cash withdrawal, because those are situations where courts have definitively ruled that there just is no negligence claim
Hmm.
there. So that's one limitation. There's also the limitation with elder financial abuse claims that we have a bit of a distinction between state and federal courts. And that means that in federal court, the court is more likely, well, almost certainly at this point, going to be pretty hostile to an elder financial abuse claim and not be willing to let that proceed. There are two unpublished Ninth Circuit opinions at this point on that issue, and the key word being unpublished, which means that they can't be cited by lower courts as precedent, which means that they aren't binding. But at the same time, they are pretty influential because it is an appellate level case, and so courts are mindful of that and likely to follow the same tenor in their opinions. And of course, there are a lot of district court opinions on the subject coming out against the elder financial abuse cause of action in favor of the banks. State courts have not necessarily gone that way. They're usually more open to the elder financial abuse claims, and there are all sorts of court rules and laws that determine where exactly a case can be brought. So that's another consideration in dealing with these cases. And then one last issue that could theoretically be a private cause of action if it were allowed, which it is not, is the failure to abide by the mandated reporter statute. So the California law requires that financial institutions report suspected situations of elder abuse to adult protective services. Um, Unfortunately, only the attorney general, district attorney, city attorney, or county council can actually enforce that law, which means that when a financial institution does not report a suspected situation of abuse, there is no remedy for the private party, and we are not aware of any case ever being brought under that section to actually enforce it. And the penalties are also very tiny if we compare it to, for example, $100 per day for not giving information about an account, or $30,000 for not doing a reasonable investigation of a claim of identity theft. The laws penalties here of $1,000 for a negligent failure to report and $5,000 for a willful failure to report are really quite small. Of course, measured against the sheer scale of the industry as well. I believe the 2024 McKinsey reporting said that banking was the most there's the most amount of money flowing out of the banking industry essentially. And in 2024, I believe that number was $6 trillion. So it's a very high,
Wow.
yeah, absolutely. These are huge players I mean, they wouldn't even bat an eye at paying $1,000. So it's unfortunate that that law isn't more useful.
Yeah. So that the code section that you just referenced is Welfare Institutions Code 15630.1. That's the mandated reporter law for financial institutions. And that's the one that's really constrained by those limitations that are in the bill that do not provide a private right of action, for example,
Mm-hmm.
and also limit what the fines are to be absolutely cost of doing business. Not even a cost of doing business. It's not even a fine when you look at the amounts of money that are available. And plus, the reality is that nobody ever uses that as an enforcement mechanism.
Mm-hmm.
What is a private right of action, and why would that make a difference?
A private right of action just means that an individual person can sue. So normally you can't just sue for a random wrong that you feel like has been done to you. You need a law that actually says that you can sue for it. There is some distinction between remedies that were available historically. We call that at common law.
Mm-hmm.
So that would be like a negligence claim, which maybe, there's not really a statute for that, compared to a statutory claim like elder financial abuse, where if you've been financially abused, you do need that law there to give you that claim. So that's the idea of a right of action. And then private right of action just means that it's a private individual bringing it, as opposed to a public agency like the attorney general or the district attorney or county council or city attorney.
Right. I just want to bring up one kind of egregious case that illustrates why this 15630.1 is so hamstrung by the lack of a private right of action. We had one case where we had a scam victim who was convinced to send a huge amount of money, and they went into the bank to take out pretty much their life savings
Mm-hmm.
and told the teller what the money was for, and the teller said, "This looks like a scam. Are you sure this isn't a scam?" And our elderly client said, "No, I'm sending it to, uh, I don't know, somewhere. It was a long time ago, so it was maybe I don't know where it was, but it was
Hmm.
somewhere foreign where the
Right.
person had never been, had no connection, and it was clearly a scam. And the teller didn't report it. And this individual, had he been allowed to sue the bank, would have had a really strong claim. But that 15630.1 does not allow an individual to sue a bank, even in a case like that, where the teller knew that it was a scam and or at least suspected it. But she articulated it in that
Hmm.
particular case. It's not usually that clear, but in that particular case, the teller actually thought it was a scam and tried to warn the senior. And we've had other
Right.
clients who have, they've gone into a bank and the bank has said, no, we won't do this. We won't send it because it's clearly a scam. And they just go to another um, branch
Hmm.
and they get it sent. Like the notes weren't put in, there was no report made, and
Yeah.
the fact is that unless you have some mechanism for enforcement, it's nice to have this as kind of an incentive for banks to train their staff, but there are no teeth in it because of the way it's written.
Right, and I mean, I could add to that. There is a bill currently pending, AB 871, which would require more specific training of staff. But even that is, it expressly says this is not even subject to the penalty.
Hmm.
So forget about a private right of action. Not even a public agency can enforce it.
Wow. Yeah, I mean, this is something that we've been talking about for a long time. It would be great for us to be able to really get a legislative change that would make a difference for our clients.
Mm-hmm.
And you also mentioned identity theft. So, can you define what that is and what it would take for someone to report identity theft? How's that done?
Right. In my mind, it's actually pretty simple to use the identity theft statute just because it consists of just using a person's personal identifying information without their consent. And that means that even just using someone's name without their agreement would be identity theft. Now, oftentimes it's much more involved beyond the name. So, whether it's using someone's social security number or credit card or debit card number or just bank account number, any information like that that's used without the person's consent can be identity theft. And that means that someone would be sending, to make a claim of identity theft, they would be actually disputing a particular transaction on their account with their financial institution. Generally, of course, it's best to do that by a letter sent certified mail, return receipt requested, just so that you have proof that it was sent and received.
Mm-hmm.
But then that triggers the financial institution's obligations to actually investigate it and determine what happened, or else be subject to the penalty that I mentioned earlier, as well as if an account was actually created, then that's where the penal code provision could come in and require the person who holds the account to give information to the victim, or else face the $100 per day penalty.
Hmm. And the Federal Trade Commission, is that they have an affidavit of fraud? Is that one way to?
I haven't actually seen that,
Oh.
and generally, with a dispute for identity theft, an affidavit isn't necessary.
Mm-hmm.
It can just be a normal letter.
Hmm.
You want to give the information that lets the bank identify the account that the fraud happened on. But other than that, as long as you give enough information to identify it, and you ideally should, of course, give them the information that helps them with their investigation, explaining when a charge was noticed, maybe confirming that you have your card in your possession if that's relevant, and things like that. That's all that's needed to give.
Okay. What other obstacles have you found when it has come to the litigation that you've been involved with? against financial institutions or anyone else involved with financial elder abuse?
It can come down to issues of collectability and also the uh, resistance from financial institutions. So, just from when a scam happens, you don't really know who the scammer is. That means that you can't collect any money from anyone, even if you are able to sue them. And that's an issue if the person is a known abuser. Let's say it's a family member and they took some money, then oftentimes they don't keep that money around. They spend it on something. And so if they don't have any money to collect and they don't have a high paying job that you can garnish wages from, then you are really out of luck in terms of suing them and getting a judgment against them. And then as to the banks, as I mentioned, they have been very successful in federal court. So even if they've been less successful in state court, that still gives them some legs to stand on in opposing a request for reimbursement of a fraudulently induced transaction.
Hmm. Okay. And moving forward, is there any kind of legislation that we're going to be working on or thinking about that might improve the prospects for victims of financial elder abuse?
Hopefully, and we'll see, I think, in the next couple of years where that goes. The Little Hoover Commission, which is a state agency, just recently published a draft report on the issue of financial scams. And so that means that the legislature is looking at that issue in more detail. The report was done at the prodding of the senator who's the chair of the Senate Banking and Finance Committee.
Who's that?
So,
Who's the chair?
Senator Grayson,
Okay.
so he's been interested in the issue and is looking for solutions. And he actually uh, he did author a bill focused on cryptocurrency restitution. So it would essentially allow law enforcement to seize fraudulently given cryptocurrency funds, and that is done for cash money, but not cryptocurrency at this stage. So it would basically just help victims get their cryptocurrency back if that's how they were defrauded. So we'll see where that goes this year, but that could be helpful. And there are other avenues that are being explored, again, just based off of the Little Hoover Commission report. And I mentioned AB 871 earlier. That is a elder financial abuse bill focused on the mandated reporter statute. That may or may not help. We'll see where it goes. And then there's another bill that has been put out by Assemblymember Schiavo that is also focused on elder abuse.
Hmm. What's that bill about?
It essentially requires, this is geared at the in-person transactions that we've been talking about. It would require customer-facing employees to give specific warnings to consumers that they think are being defrauded.
Hmm.
And if the bank does that, then they have no liability whatsoever from the
I see.
transaction.
Uh, okay. I'm processing that.
Right.
No liability. Banks like that a lot.
Yes, I agree. And I actually don't. There is a bit of a loophole in how the bill was drafted to where I don't know that the so-called preventive measures ever really need to be given. Um, but
That's not good.
that is, yeah.
Okay.
So we'll see where it goes.
Okay. Well, that kind of catches us up to where we are right now with regard to financial elder abuse litigation. It's been kind of an uphill battle. Like the banks do lobby pretty strongly to avoid any kind of liability on their part. So that's part of the issue for us. But we will definitely keep our bill tracker updated, and we'll see where we are in the future.
Yeah, hopefully somewhere good.
Yeah, hopefully. Thank you.
All right, thank you.